Hi, my name is Lori Conroy. I'm an assistant United States attorney. I work for the Department of Justice. And today I'm here to offer some suggestions and what I think are best practices for prosecution of cases involving child abuse. When you have a child who is a potential witness, the best advice that I can give based on my experience is that early and often meeting with them is best. If you have a child who was interviewed in a children's advocacy center setting, this provides a good opportunity to staff nearly immediately how you may introduce the prosecution team to that child and begin the process of preparation. Start in a place where the child is comfortable and with people that they're comfortable. Again, if you have had a child who has been forensically interviewed, and they are receiving wraparound mental health services following that forensic through a children's advocacy center, that's a great place to start. Staff it with the team and ensure that you have the right releases and the right setting to be able to talk to that child. The first meeting with a child should be nothing more than a brief introduction. Usually you want that just to be with the prosecutor and perhaps with one other person with whom they're comfortable. In that first meeting, I simply tell the child who I am and what I do. I tell them I don't need anything from them that day. I just wanted to meet them. And I tell them that I don't know them, but I'm very proud of them and that I am thankful that they were very brave and told someone what happened to them. And if it's okay with them, I may want to meet them again and introduce them to some other people that I work with. In a later meeting, you may also want to think about taking the burden from the child. Sometimes even young children can feel pressure from caregivers and from others, like we're in this mess, the mess being a criminal investigation or prosecution because of the child. And I usually like to explain that my role as a prosecutor is to take the information that they gave and that everyone else gave in the case and to decide what's next. And that if they feel like anyone is making them feel like it is on them, it's not, it's on me. And I usually give them my business card and say, if they want to know who did all of this, they can give them my card. I had an experience with a child who had unfortunately lost a young sister and had been severely abused and neglected himself. And we knew because of his experiences and because of his age and his development that getting him to the point of being a witness at trial was going to be a challenge. I spent a number of very brief meetings with him in the context of his therapy sessions with the permission of his guardians and his therapist, just simply saying hello, building paper airplanes, and flying them down the hallway. All of this was just to ensure that if we got to the point where this young man had to come into a courtroom and talk about what was undoubtedly the worst experience of his young life to date, that he was comfortable with me asking him those questions. Meet the child where they are, figuratively and literally, and give the child as many choices as you're able to give them. It could be something as small as wait for the child to enter the room. Ask them where they would like everyone to sit. Ask them what they would like for you to call them. If it gets to the point where labels are being identified, which usually would not be in the trial preparation stage, ask them how they want to be known. Do they identify as a victim? Do they identify as a survivor? Find out if they identify as a particular cultural group or male or female. As you're exploring what the child wants at the appropriate time, you may also want to explore with them and with their caregivers with whom they're most comfortable, who best to answer these questions. I recently had an experience with a survivor who told me that he felt much more comfortable talking about sexual abuse perpetrated against him by a male perpetrator, talking with a male attorney and a male investigator than a female. These are things that you want to be thinking about so that you can build your trial team around what that child is going to feel most comfortable with, recognizing that there's going to be so many things that are beyond their control in the courtroom, including being there themselves, and give them some choice and some power back. Keep it simple in time and in language, no lawyer speak. I struggle with this myself, and I find it very helpful at the point where you've introduced someone else, perhaps a victim specialist, maybe there's an advocate, maybe there's a guardian who knows the child, and have them watch the child. And if there's something that you as the attorney are explaining, and it seems that the child is having trouble understanding it, encourage that person to interrupt you and ask you to explain it in a different way, or perhaps let them explain it in a way that they know the child would understand it. Take some time with these meetings. Pause, adjust your pace, listen to the child. Take some notes so that the next time you meet with the child, you remember the things that they enjoy doing, the school subjects that are their favorites, the sports teams or characters on television that they enjoy. Take a genuine interest in this child and make these experiences more about them and the things that they like than what you need from them. Build on these meetings until the comfort level is high. And then at that point, you start beginning to explore some of the more substantive information that you need in a case. When you get to the point that you are talking about the case, there's a line from the musical Hamilton that I always think of. It says, "Talk less, smile more." Think about this. The child or the adolescent or the young adult that you are interacting with has never been in your position and you've never been in their position. This is likely one of the most serious, humiliating, embarrassing, emotional things that they have ever dealt with. Do not compare yourself to them. Do not compare your experiences to them. Simply listen and ask the why questions. Recently, in preparing for a different training, a survivor told us that he was expressing his concern about moving forward with charges related to sexual abuse he experienced as a child. And he felt that the prosecutor, when the prosecutor says, "Well, it's my job to charge," didn't properly understand the fear he felt about the perpetrator. And that it wasn't that he was reluctant to move forward with prosecution, that he just wanted someone to hear him and express that they understood his fear and validate that. You cannot put yourself in their situation. You should not compare in front of that child to other cases, other prosecutions that you've experienced. Remember that this is very likely the most significant thing that this child has ever experienced. Just because a victim doesn't act like we think that they should, does not mean that they are any less a victim and a survivor of child abuse or child sexual abuse. One of the purposes of meeting with a child in more than one setting, in more than one experience, is to see how they react to particular situations. Recently, in reviewing some sex assault nurse examination paperwork, I had an observation that this particular patient was noted by the nurse to be giggly. Now, at first blush, you may think that that's a counterintuitive response to being the victim of a sexual assault. However, the more you get to know a child and those who are their caregivers around them, the more you will learn that that's likely a response to being nervous. And if you know that, that's something you can explore with them in front of the jury or with another witness in front of the jury, so the jury understands why the child is acting the way they do when they're on the witness stand. Understand that a child's feelings about abuse are complicated. Statistically, we know that most sexual abuse is perpetrated on children by someone they know. It may even be someone they love. And so their feelings about that are complicated. They may feel embarrassed. They may feel as if they have done something wrong. They may love the perpetrator. Their family members may love the perpetrator. So understand that as they are meeting with you and as they're dealing with all of this and processing with it, their reactions may be different. They may be flat in affect. They may be giggly. They may be closed off with body language that indicates they don't want to speak to you. Listen to them, ask them questions about how they're feeling, gather information from those around them so that you can best address those things as you continue to meet with the child. When you get to the point that you believe a child may have to testify in the courtroom, be very deliberate in how you introduce a new setting. Ideally, your past meetings with the child have been in an environment where they are most comfortable. But at a certain point in trial preparation, you do need to transition into your workspace and eventually into the courtroom. Be sure that the first time that the child sees the courtroom is not the day that they come to testify. There are great materials out there by different groups that will give you a diagram, even some books about who is who in a courtroom. Use those materials, bring the child into the courtroom, show them where you will be sitting, show them where they will be sitting. If there's a microphone, have them speak into the microphone. Oftentimes a witness box is raised and it is the focus of the attention in the courtroom. Be sure that that child is as comfortable as they possibly can be in that setting. Identify where the person who had harmed them may be sitting. In different jurisdictions, there may be opportunities for a child to testify remotely. That may not always be the case, and so you'll want to put careful consideration into how best to make sure that if the child has to be in the courtroom with the perpetrator, how they can be most comfortable. You may want to tell them they don't have to look anywhere but at you. They can look at the jury, they can look at the judge, and talk to them, ask them where do they think they may want to look. Explore all of these things, perhaps in a number of different meetings, so that they are comfortable in the courtroom. Think about the supports that the child might want to have going into the courtroom setting. Ideally, a child has been engaged in mental health services and they have supportive people around them. Even think about their physical well-being going into this and make sure that they have resources that are available to address these things. Know that when you are in the courtroom setting and the child or the adolescent, young adult takes the stand, that it's not going to be like it was in preparation. In my experience, their demeanor and their descriptions are more subdued, more flat in the courtroom. I will often tell a child that it's okay to have big feelings about coming into the courtroom to testify, and when you're on the stand, you don't have to be strong, but if you feel like that's how you need to be, that's okay too. But just know that it's not going to be like it was in prep. When you are preparing for their testimony, think about things that you can do that will help them be grounded. Make sure you tell them that they should ask if they need a break. Be sure you tell them that if they're feeling a little lost, that there should be some water in front of them. Take a drink, feel how cold the water is. Take a moment and just concentrate on that. Oftentimes, there may be some objects that a prosecutor's office has that a child could choose from to just have something in their hand that is not a distraction, but something that they can ground themselves with. I've heard of small stones, perhaps stress balls. I like to start to work with the child with those objects to see how much of a distraction they may be leading up to their courtroom experience. Touch base throughout the prosecution and empower the child in this process, because there will be many things that they do not have a choice over. And the more that we can meet with them, the more we can do to decrease their anxiety and any pressure that they may feel, the better the outcome will be, no matter what the outcome is in front of the judge or the jury. These are difficult cases, the most difficult that a prosecutor can handle. And when we are putting a case in the hands of a judge and a jury, the outcome is not a sure thing. But you want to ensure that no matter what the outcome in the courtroom is, that this child's experience are not re-traumatizing, and that you can do what you can to make them feel power and feel good about the fact that they walked into a courtroom and they were able to tell a judge and jury and others what happened to them. And remember that, as one victim said, and I recently heard this at a training, this is not just a case to them, this is their life.